The next matter to come before the court this morning is State of Ohio versus Ketsy, Padilla. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal if the appellant wishes to reserve that time. I'm keeping the clock this morning to keep you apprised of the passage of time. The court has read the briefs and we are ready to proceed when you are.
Madam Presiding Judge, and may it please the court, my name is Mark Andrzejczyk and I represent the defendant appellant in this matter, Ketsy Padilla, who appeals from her convictions of felony 1 drug possession and trafficking, cocaine, possession of drug abuse, and her corresponding sentence of 11 years and financial sanctions and so forth. She's assigned one assignment of error that the trial court erred when it denied her motion to suppress the evidence being presented against her. We submit that the assignment of error should be sustained because Ms. Padilla did have protectable Fourth Amendment interest sufficient to confer standing under a motion to suppress in the things searched, which is the parcel of cocaine that was intercepted and searched at the post office in Cleveland, and significantly, the home that was invaded to find Ms. Padilla in possession of the parcel of cocaine in her kitchen. Whether an individual has an expectation of, has a Fourth Amendment interest in a property is determined under the legal standard provided by Ketsy versus the United States in 1967. And we looked whether the individual had a legitimate expectation of privacy in the place searched or the things searched and seized. In Justice Harlan's concurrence in Ketsy, he set out the two-part test that became the test to determine a legitimate expectation of privacy in Smith versus Maryland. That is, the individual asserting suppression must have a subjective belief that the property that is the subject of the motion to suppress will remain private, and that society is prepared to recognize the privacy in that item. In other words, that there's a subjective and an objective belief that privacy is protected, and the court determines this under totality of the circumstances analysis. And I ask that the court review the trial court's legal conclusions de novo and accept only the findings of fact if they are supported by competent, credible evidence. Moreover, I'd like to suggest that the trial court erred further procedurally in considering the issue of standing initially without hearing the merits of the case. Rockus versus Illinois, Rawlings versus Kentucky, and the United States Supreme Court cases have said that standing is merely part of the overall analysis on the motion to suppress and shouldn't be considered as a separate threshold issue for an individual.
When the court was undergoing this standing analysis, what was argued was actually whether or not there was a reasonable expectation. I mean,
Precisely, Your Honor. But Ms. Padilla wasn't allowed to present any evidence and, cross-examine the police officers who were involved and do all the things that one would be able to do in a motion to suppress.
Was there a request made to do so on the record?
My understanding is that there was a set of stipulation of facts, but the court had indicated that there would only be a hearing on standing initially. So it's not exactly clear to me whether the defense counsel was able to present the evidence that he wanted to, or the court made it clear that we were only going to consider standing. But getting over that, even with the facts that were used in the hearing that was simply on the issue of standing, I submit to the court that Ms. Padilla should be considered to have that standing and be able to challenge the search and seizure involved here. First of all, it would have been objectively reasonable for Ms. Padilla for anyone to have a privacy interest in a parcel of mail that is sealed in an envelope concealing its contents. The courts have said that, roundly. United States versus Jacobson is a Supreme Court case on the issue, and there's a number of other cases that have said that about mail. Also, the home is the most protected.
Before you get to the home, would a next door neighbor have a privacy issue in a parcel that is delivered to the home next door to her, not with her name on it, but just it's a parcel that someone has an expectation of privacy? Or
Perhaps
would the neighbor be able to?
I don't believe that the neighbor would be able to challenge, Your Honor, but what's so significant here is that this parcel was addressed to Ms. Padilla's residence, where she lived with the named addressee.
Right.
And then after that, she exhibited all of the trappings of someone who had an expectation of privacy in the parcel.
Well, according to the briefs, though, she initially said that she had no interest in it, that it wasn't hers, that it belonged to someone else. And from the briefs, it sounds as if even after the arrest at the station, she continued to deny that she had any ownership interest in it. And then later,
Well, that's where
changed courses.
Well, not entirely, Your Honor. What I submit to you that is so important here is that perhaps at the beginning, her knee-jerk reaction was, no, it's not mine. But later on, she did admit, this was cocaine that I expected to be coming in the mail. Ariel Gonzalez, the addressee, had asked me to pick it up. I did pick it up. And then when we looked at the other factors that courts use to analyze the subjective prong of the CATS test, whether the individual exhibited ownership, possession, and control over the item, whether they had a right to exclude others from the place search, the precautions they took to maintain privacy in the item, whether the person by her conduct exhibited a belief of freedom from government intrusion, the legitimacy of the person's presence in the place searched. We have to find those factors militate in favor of Padilla having her conduct showing a privacy interest in that item. I mean, not only did she agree with Gonzalez to the addressee to accept it, but when she accepted it, she took it into the home, closed the door as a cat, to borrow a line from CATS, and closing out the rest of the world, taking it into her own privacy where she believed that she would be in private. So all of these factors.
Well, except that the brief also indicates that there were other individuals not only in the home, but it sounds as if in the very room where the parcel was open when the I don't know if they were deputy sheriffs.
No, in part, I mean, that's true, Your Honor, also, but what happened was that there was someone named Raphael Escalante in the room at the same time. But the United States federal courts have said, in particular, United States versus Lyons addressed this and said a person may admit specific persons into an area without renouncing his or her assumption that he's immune from intrusion by others. So because she allowed Mr. Escalante to be there doesn't mean that she was consenting to anybody else being there, and particularly the government to being there. And certainly she was in the privacy of her own home. That the court has roundly said we preserve the right of the home to be somewhere that a person can retreat and be free from government and other intrusions. The court said that in United States versus Silverman, Minnesota versus Carter. Moreover, other cases, the United States Supreme Court just decided a case in 2006 called Georgia versus Randolph, where they said that a present co-occupant in a home cannot consent to a government search of the home over the objection of another present co-occupant. So, for example, the trial court said, well, because Ms. Padilla lived at this house with her mother, Hernandez, she had some kind of lesser interest in privacy in the house, and that's simply not true in light of Randolph, Georgia versus Randolph, where if Hernandez was present, which he was not, and Hernandez said, okay, you government, you can come in and see what we've got going on here, and Padilla was there, and she said, no, you can't. Well, if the government went in pursuant to Hernandez's consent, then that would have been an illegal search. Because Ms. Padilla had an interest in privacy in that house. So, excuse me. So just because she had housemates or guests that she specifically allowed into the area, probably believing that they were the only ones who were going to be in the home with her at the time, she had a legitimate expectation of privacy at that time, and just simply having that individual there doesn't vitiate that. The governor also argued in the trial court, I don't think the trial court really touched on it, but that because Ms. Padilla disavowed ownership originally, that she somehow relinquished her rights in that parcel. The cases the government cited in support of that don't consider the item being searched to be in the home. And I think I submit that that's significant. In the cases where the item to be searched was in the home, we've cited State versus Maston, where an individual kept a locked file cabinet in the common area of his home with child pornographic pictures in it, He disavowed ownership of that. The government argued, well, it was in a common area in the house and other people could conceivably get into it. He disavowed ownership of it, but the court said, no, he has standing there because it was in his home. Same thing with State versus Clark. Police officer followed a woman into her home, saw when she opened the door she had drug paraphernalia in the home, said it was a plain view search. Well, he went into her home and she never did consent, and the court found that the officer had gone too far and upheld and granted suppression. I think that the case that is most factually analogous to this case is United States versus Sheldon, a 2004 case from the District of Hawaii in Sheldon. You had somebody who, a mother accepted a package on behalf of her son. Her son's name, Raymond Sheldon, was the addressee. The mother, Hannah Sheldon, accepted the package on his behalf, knowing that it contained cocaine. This was, again, similar to Padilla, and a controlled delivery. Like Padilla, she took it into her house and opened it up, and there she was found by officers who had invaded into her house and arrested her. She was found to have standing. The government argued she did not. The court evaluated the factors of the subjective prong and showed that her ownership, possession, and control of the item at issue and precautions she took to maintain privacy in the item were significant, determining she had a subjective interest in privacy in that item.
And you have you have 4 minutes remaining. You may reserve or continue as you wish.
I would also say to the court, the Fifth Circuit's decision in United States versus Villarreal is another situation in which the addressee of a parcel was not the person who received it and was arrested. That person, Villarreal and Gonzalez, used fictitious names and intermediaries to pick up 55-gallon drums of marijuana on their behalf. They then brought them into their pickup truck, and they left the pickup truck at a bar, and that's where the police followed them and found that there was marijuana in the drums. And they were found to have standing and allowed to move to suppress, and ultimately it was granted because the search of the drums on the shipping dock was illegal. I would submit that they had a much weaker case than Ms. Padilla does, because here again, Ms. Padilla had a conversation on April 16th with Mr. Gonzalez. He said, "We got this cocaine coming in. I need you to take delivery of it." She agreed to do that. She went on April 17th while under surveillance by the police. They saw her looking out on the porch for the package, taking reasonable steps to preserve the privacy of that. If it was left on the steps, she didn't want it to be there for long at all. She took it as an act. It wasn't there. She went to the post office looking for it in Gonzalez's car. She went to take delivery of it and take it right into her home, closing the door, shutting out the rest of the world, and from in her own mind, in which we all, I think, would agree it was reasonable for her to believe once she shut that door that she was in private. And so for those reasons, I submit that Padilla exhibited by her conduct as required under Katz and Smith v. Maryland and the progeny of those cases, that she had a subjective privacy belief that the parcel of cocaine would be private and that her conduct within her own home would be private. Those items and places are considered objectively reasonable to believe they have privacy in. I ask that the court reverse the trial court's denial of Padilla's motion to suppress, as the court vacate her convictions and remand the matter for further proceedings as appropriate. Thank you.
My name is Natasha Guerreri, and I represent the state of Ohio, the appellee in this matter. But first and foremost, I guess I would just like to clarify that the motion to suppress in this matter was a challenge of the constitutionality of the canine sniff, as well as a subsequent search of the actual package itself at the postal office. And therefore, that was where the issue of standing came into play here. And there's no question that individuals have a privacy right in a sealed mail package. That definitely comes to the person who is not only sending it, but as well as the person who is the recipient. Other factors come into play where a third category of individuals can show some sort of ownership or that they were in fact the intended recipient of that package. And the state would submit that none of that evidence was actually presented to the trial court that would allow Padilla to challenge the search in this matter and the canine sniff. Here, there's no question that she was neither the addressee nor the sender. She was the living girlfriend of the recipient of the package. There was no evidence that the name of Ariel Gonzalez was something that she used as a fictitious name on a regular basis that would somehow afford her a privacy interest in that way.
You said living girlfriend. What the facts and circumstances of the case is when the package was delivered, that Mr. Gonzalez did not reside at that home. Is that correct?
And I may have misquoted that, but I believe that Gonzalez was at least at some point residing with the Miss Padilla and her grandmother. But I could be mistaken with
I
regards to that fact.
think that the briefs do say that, but I recall that at some point, but there, I think there's an assertion therein that at the time that the package was delivered, that he was not residing at the home, as opposed to just he was at work. I'm not sure, but.
I apologize, Your Honor, and I may have misquoted that it may have been at some point in the past that he did reside there, and at that point he may not have. So I do apologize if I did mistake that.
What are the facts of in the findings in Sheldon that are different from the findings made in this particular case on the issue of standing?
Certainly, Your Honor. In Shelton, there was evidence that there was a package that was being delivered in the defendant's son's name. And it was the son actually indicating to his mother that you're going to be getting more drugs and there's going to be a package of drugs that were going to be delivered. It was delivered in his name, but there was not only the son, the package was in his name, but also the defendant in that matter, stated that they both knew and were that they both realized that, in fact, the drugs that were being delivered were in fact the defendant's. There was no question, there was no disclaiming by the defendant that those drugs were hers. Additionally, the defendant in that matter actually did sign for the package, took the package into the house and actually hid it under her bed, which is distinguishable from this case in that Ms. Padilla stated that the drugs were actually her boyfriend's. That's what she stated right when the police arrived and executed the anticipatory search warrant, that the drugs were her boyfriend. She did realize that there were drugs in the package, but that she was accepting it on his behalf. She never claimed any sort of interest in that package. And additionally, I don't know if in Shelton there were any other individuals at that point in the residence, but in this case there was a third party here after Ms. Padilla opened the package. So there was evidence in Shelton that both parties involved, both the defendant as well as the named recipient on the package, that the defendant in that case was actually the intended recipient of the drugs there.
And so in Sheldon, you're saying that the person who was charged, the mother,
Yes.
was the intended recipient?
Correct, Your Honor. Correct.
Even though the package was addressed to her son?
Correct. And there was the evidence that the son had told her that there's drugs coming for you, and that these drugs she was aware were coming for her, and that those were her drugs, despite that fact. Yes, Your Honor. And in addition, Ms. Padilla cites to the case of Maston with regard to a search of a home where there was a locked cabinet in the residence. The defendant in that case was not the homeowner, however, the wife was the homeowner, and she provided consent to search the residence. The evidence in that case showed that that locked cabinet was the defendant's. He personally used that cabinet, and he was the only person that actually had keys to that cabinet, indicating that he did, in fact, have a privacy interest in that cabinet and the contents therein, because he was the only person who had access to what was contained therein, and therefore his wife could not provide consent to search that area or that particular locked cabinet, which is distinguishable obviously from this case in that, again, the package was addressed to Ms. Padilla's boyfriend. She indicated that, in fact, the content of that package was not intended for her and she had no interest in it. And additionally, in the Clark case, in which the defendant there disavowed any sort of ownership in the drugs that were found in her residence, that was reversed based upon the fact that the law enforcement actually was illegally within her residence, that she did in fact have a privacy interest in her residence. The law enforcement were there based upon an illegal arrest, and therefore anything that came as a fruit of that particular search would not be submitted against the defendant.
So the Clark case didn't involve a search warrant?
It did not involve a search warrant. There was no search warrant. Basically, in that case, the officer indicated to the defendant, hey, you can either give me the certificate of title now, I can go with you and go grab that from your apartment. It was something with regard to a car, or you can bring that to me later at the station, and there was some indication that the defendant felt she had to take and go get that certificate of title to the officer, and the officer just came in with her, and that's when he discovered the drugs in the apartment. So those facts are also distinguishable from this case. Therefore, the state would submit that, in fact, the trial court was correct in determining that Ms. Padilla did not have standing in order to challenge the search of this package through the use of the search warrant at the postal inspector's area because she had no privacy interest in that package.
What if their argument that she had an interest in the place where the package was taken in her home, in her own home? How do you respond to that?
And in fact, she does have a privacy interest in her home. There's no question about that. However, here there was a search warrant for the home, the intended home, the address that was actually, the package was delivered. Therefore, that particular issue was addressed through the use of the search warrant to actually enter the home. They didn't illegally go into the home and just go after the package. They had a science report by a judge to allow them entry into the home. Therefore, the state would just request that this honorable court uphold the decision of the trial court as well as the convictions against Ms. Padilla. And if there are no further questions. Thank you, Your Honors.
Counsel, you have about a minute and a half remaining.
Thank you, Your Honor. I would just point out to that point about the place where the search took place. That matters. It's a huge factor in this case, and I think the trial court here very much in deciding that was insignificant. Courts have held that we measure the privacy interest throughout the whole delivery, and so we measure this at the home rather than back at the post office. Courts have said that, explained that, and Sheldon has a good explanation on it. Koenig in the Seventh Circuit of Villarreal also talk about that. It would be too much of a burden to place the measuring of the interest at the post office, because then either an addressee or a non-addressee or whoever was claiming that the package was for them would never be able to put forth a showing that they had legitimate interest in privacy in it, because we wouldn't know where it was going, and we wouldn't be able to measure their conduct to find the subjective prong of the test. So the place is significant. The challenge, although it was for the dog sniff underlies both warrants. Both the warrant that the United States Federal Court issued to search the package and put the electronic transmitter into it, and then there's a warrant for the home, but the underlying warrant affidavit had to do with the dog sniff, and the dog sniff alerting to the presence of the cocaine. And that affidavit was incorporated by reference in the Lorain County Court of Common Pleas warrant that allowed the law enforcement to enter into the home when the electronic transmitter was triggered.
regrettably, I need to inform you
That's
it's the end of
fine.
your allotted time. Thank you both for your presentations this morning. Court will take the matter under advisement, issue a written decision, which will be mailed to both sides and posted on the Ohio Supreme Court website.
Thank you, Your Honor.
Thank you, Your Honor.